If we have a juror who we can prove that is unsound of mind to the point that they aren't capable of performing the jury duties, that doesn't happen very often. Although I can remember one case where the judge said in private, well, that prospective juror is still living in the 60s and under the influence of something. And so the judge excused that juror because the juror obviously wasn't processing very well. There's challenges for bias, and bias are those situations where the juror is related to the defendant or to the victim, and this can be an employment relationship. It doesn't have to be a blood relationship or a marital relationship. Something that would create a bias, a prejudice for or against the defendant or the victim. Where the juror has been opposing the defendant in a civil case, or where the juror has filed criminal complaints against the defendant. Yeah.
Oh, so they also asked, I remember, if you were related to the, or friends with the attorney.
Yes.
Or anyone else in that court system.
Yes. And they'll ask those questions, whether you know defense counsel, whether you know the prosecutors, so that we can explore whether there's any actual bias, whether there's something about that knowledge or relationship would affect the juror's ability to be impartial. If you served on the underlying grand jury, well, obviously you aren't going to be allowed to serve on the trial jury. If there was a co-defendant and you were a juror in the co-defendant's case, then you don't get to be a juror twice on the same facts. If there was a mistrial and you were on the prior jury, you don't get to go through again. And the big one is the last on the bottom, where the juror has formed or expressed an unqualified opinion or belief that the statute says the prisoner, we generally say the defendant, is guilty or not guilty of the offense charged. And that's one that we really focus on both from the defense perspective and from the prosecution perspective, because the whole idea is we're supposed to have a jury that will listen just to the evidence in court and base their verdict only on the evidence that they heard in court. That doesn't mean that they can't have heard something else some other time, but they have to agree, and we have to be satisfied that whatever they've heard in the newspaper or otherwise, that they set that aside and they render their verdict only on what's presented in court. That's the essence of how our jury is supposed to work. In capital cases, there's a specific disqualification if a person holds a conscientious opinion, typically an opinion opposed to the death penalty. Then that person is not going to be required to serve in a case where they have that conscientious objection to it. And if they aren't able to act with entire impartiality. Now, there are also what are called peremptory challenges. These are the lawyer's secret weapon, right, Ray?
Yes.
Yes. Peremptory challenges, the lawyers don't have to state a reason. We get a free shot, so to speak, to unselect people from the jury who, for whatever reason, we don't believe that they would be appropriate jurors in our case. We don't have to state a reason. The disqualification is done secretly, so the jurors don't know who disqualified them. Just the attorneys and the judge know who is being disqualified. But we don't have unlimited numbers of peremptory challenges. If the maximum penalty for the crime that's being tried is death or life imprisonment, then each side, the state and the defense, get 10 peremptory challenges. All other felonies, it's 6 per side. For misdemeanors, 4 per side. Now, we haven't mentioned yet alternate jurors. The law allows the judge to impanel alternate jurors. 1, 2, or even more additional jurors to sit on the panel and hear the case with the understanding that if something happens to one of the other jurors, they fall ill, for some reason they can't continue service, then this juror will just fill in their place. If the judge is going to impanel alternate jurors, then we get additional peremptory challenges up to 2, depending on how many alternate jurors the judge is going to impanel.
Bill, are
Yes.
there always alternate jurors?
No.
And if there are, how many are there?
It depends on the case, and generally it's determined by the judge's expectation of how complicated the case is going to be and how long it's going to take.
Okay.
For example, our misdemeanor cases, which are generally tried in one day, it would be rare to have an alternate juror. But if we're looking at a serious trial that might take 2 or 3 weeks, the judge is going to impanel alternates. Because he wants to make sure if somebody has a death in the family, if somebody has illness, something happens, that we don't lose the entire trial because we lost one juror.
Bill?
Yes.
The preemptory challenges, now, I'm not gonna say I haven't been in a jury pool for a while, because Henrietta put my name at the top of the list. Let's just say I can't remember exactly how the process works, but you have a whole bunch of people come in, and then they pull a whole bunch of names out, and they say, rest you can go home.
Okay.
So, okay, so that preemptory challenge comes, first of all, after that, right?
After that.
Okay, and then, so then they pull X number and they see who they pick out of this? And
It comes
is it
after
through-
that.
It's after that, so
Yes.
it comes at which point in all of
It
that
comes at the
process?
tail end of the jury selection process, which is what the lawyers call voir dire. And we'll get to that, voir dire. We'll have that here, I'm not gonna spell it for you, because it's right there. Isn't that like magic? It's amazing how smart they make computers, they knew what we were talking about. Just jumped right in there. Okay, the selection process in the courtroom starts as Susan described. We'll have a panel of jurors, maybe 40 or 50 jurors who are brought in on a given case. And where we'll start out is the clerk will draw at random the names of what we call our strike panel. That would be 12 jurors for the trial, plus enough jurors to cover all the peremptories. So say we have a regular felony case. Let me go back and look at my numbers here. Whoops. There we go. Regular felony case, so it's 12 jurors plus 6, right? 12 jurors, then 6 preemptories for each side, so 12. So the judge will call 24 people. And they will go into what we call the strike panel at the front of the courtroom. And that's when the judge starts asking the questions. And the judge will ask all those general questions. Is anyone here who doesn't read, speak, and understand the English language? Everybody raises their hands. And all the other questions. And then the judge will let each attorney ask questions of the panel. And the purpose of the questions is not to argue the case, although attorneys will... Ray's smiling at me. Attorneys will always ask questions that maybe highlight potential issues in the case, because we want to know what a juror thinks about something that might be relevant to the case. That's going to help us in deciding whether this person is the kind of juror we want on the case, or somebody we don't want on the case. So, yeah, Dave.
I don't know if you remember this, there was a case some time ago with a fellow who was inflicting AIDS on unsuspecting people.
Yes.
And I was selected for the jury, and I knew you, and I knew Chuck Hoffus, the defense attorney, I knew Judge Stegner, all 3 of you. But I figured nobody was saying anything, so that wasn't going to be, and you all knew that I knew all of you, because we
Sure.
worked together in drug court. Then I saw, after the jury was picked and the trial started, I saw one of my clients come up as a witness. And I wrote a note to the judge, and I says, what do we do? And so you called me in, the judge did, and then all 3 of you decided that it was okay for me to be on the jury. And I've always wondered if this is a small town and everybody knows everybody else, if it had been like Seattle or San Francisco, would I have been allowed to stay on the jury?
Yeah, I don't know. Ray, you've practiced in larger jurisdictions.
Not much larger. But to answer your question, I think the same process would have happened there as happened here. You'd been questioned by the judge and both the counsel, and if they agreed that it's okay for you to stay on, you'd stay on. If somebody had an objection, I think even here, you'd probably go on.
And if there hadn't been enough alternates, what would have happened?
The judge might ask the attorneys if they're willing to continue with less than 12,
So that's a case where
or
it might be less than
we would
12.
have a mistrial and have to start all over again.
Just during the selection, you could get a mistrial?
Well, no, he
This
was
is after
actually
starting.
Oh,
panel,
when the witness.
and this,
came, right, I
and
got
didn't realize that one of his clients was a witness until after the jury was already paneled. So, the attorneys will ask questions, the state goes first, because the state has the burden of proof, and we always go first. The defense counsel will ask questions of the jurors. We try to engage each juror, we try to get a read for who you are. And so that we can make a decision as to whether this is the kind of case that we believe you would be appropriate to serve on the jury from our perspective. It's called jury selection, but I'll tell you, practically speaking, it is really jury deselection. what both sides are doing is trying to identify the jurors that scare us the most, for whatever reason, and we get rid of them. And both sides are then stuck with, for lack of a better characterization, who's left over. Hoping that those, if they're the folks who are left over and we're scared about them, we aren't as scared as we were about the people that we took off the jury.